All right, good day, class. Today we're going to talk about employment law, right? So, one of the major things that HR does is make sure that all the laws are being followed by the company, right? That really is one of the major functions of HR, right? And this HR really relies on the body of rules that exist based on the Department of Labor, and just the general guidelines, the acts that are out there that help to manage HR and manage the rules for how to operate in a corporate setting, and how to take care of employees, and when they have grievances and issues, how do we go about kind of figuring those things out? Okay, so when it comes down to really, HR law, right? We're just trying to make sure that we avoid any exposure uh, that the company can face because of poor behavior or actions taken by individuals within the organization that are less than moral or very not, just not good, right? Poor decision making, poor actions, and detrimental to the um, the well-being of the company, right? And so we're trying to make sure that we not cost the company any money, and also we're a fair and equal employer, all right? Equal opportunity employer. And you've heard that term before, being an equal opportunity employer. And all that really means is that no matter where you from, what color you are, what religion you are, what your sexual orientation is, um, aside from your skills and your abilities, nothing else should really um, prevent you from being hired, right? Unless you don't meet the requisite skill set that the company is looking for. Okay, so the first concept we're going to talk about is employment at will. And so employment at will is something that a lot of states use as a policy. Okay, and all employment at will means is that uh, the employer can relieve you of your duties or get rid of you at any time they want without giving you any real reason, okay, or for no reason whatsoever. All right, on the same note, you can yourself leave your employer, and not give any rationale as to why you left, what were the reasons and that kind of thing, right? And so it's a good tool, to have as an employer, because it provides you flexibility to kind of move people out, bring people in, and also gives the employee flexibility to kind of come and go as they please if they feel that the organization isn't a good fit for them. There's no um, negative connotation associated with it. Just a matter of, hey, it's just not a good fit, or whatever the reason is. I can let you go. Okay. So for the most part, employment at will applies to all the workforce except in certain situations, right? So one, collective bargaining, right? CBA, right? Basically, CBA is a contractual agreement between the management and the workforce, saying we're going to abide by these particular provisions, and you're going to do this. The employer will do X, the employee will do Y, right? And knowing what a CBA, it's set for a certain amount of time, and then at that time, once it expires, we'll come back to the table and we will, renegotiate a collective bargaining agreement. Right? It's sort of in the mode of a union, sort of, but not as not the same per se. There aren't any dues or anything like that. There aren't any meetings. It's just the whole point of, hey, as a group, we like to see these things for everyone across the board, right? Whether you are, in the union, not in the union, there's no union, whatever the case may be, right? Doesn't matter. The next situation is express rent contract. So if we have a contract between each other, the terms of this contract is what will serve as the guideline for our relationship. Okay, serve as the guide. So express written contract is basically it's written out. You can read it, right? It's clear, black and white, and these are the terms of the contract, right? And so it says, you cannot be terminated via employment at will or something to that effect, right? So if you have an express written contract, employment at will, Third situation is terms of implied contracts. Okay? When you look at the terms, right, and there's certain things that are implied within a contract that are necessarily written. Okay, for example, it's implied that I will get paid a salary, right? That just comes with the territory. Okay, it's implied that it's somewhere in there that I'm gonna, get breaks or have an opportunity to, to do some other things as far as develop and train and have some space or some time to do other things, right? So that may be implied in the contract that is not necessarily expressed, right? Expressly written, right? It's not in black and white, but everybody understands that it kind of comes part and parcel, right? So it's implied. All right. The next one is judicially determined public policy exceptions, right? Again, depending on what policies are out there that are laid out by the city, the state, or the federal government, right? Employment Act rule may not apply. Okay. And also, as I said, federal, state, and local statutes, right? Which prohibit discrimination in employment against given specified protected classes, right? There's certain, classes, either be religion, sexual orientation, um, um, uh, creed, color, right? That employment at will just is not gonna, doesn't apply. Okay, and so you definitely have to take a look at all those, look at the situation, and see how employment at will applies. But for the most part, employment at will is pretty common thing, and within the state of California, employment at will is definitely in full use and full effect. Just again, in those certain situations that I previously mentioned, employment at will has to be looked at and just compared to, okay, is this something that we can actually use? If not, then we have to, abide by the rules that we, agreed to. That's all. All right. Okay, so let's talk about civil rights acts. Okay, so the first civil rights act was in 1866, and basically it, talked about, the first set of rules governing the behavior of employees and employers, right? And what were the rights of um, employees as far as, being, hired or not hired based on, things that didn't have to do with their skill set. Okay, so when and again, if we you have to think about it this way, that in 1866, when we talk about the Civil Rights Act, it strictly pertained to white males. Okay, not females, not women, and definitely not minorities of any kind. Okay, it was strictly for white men because they were considered a man, a whole person, whereas minorities and women, well, many women fall in that category, minorities in the workplace, were not considered, whole people, and so they didn't weren't protected in the Civil Rights Act of 1866. Okay, um, so in 1866, of course, it was the initial act, so it was really very, it didn't cover a lot of situations. It was very, not a lot of substance. Just, didn't really do a lot, but it was the first step in a line of, more steps to come. All right. Civil Rights Act of 1871 gave, employees the right to sue, right, if they felt like they something had been violated or they felt like they were treated unfairly under the Civil Rights Act of 1866. So basically, there was an amendment to the act, and so that was added on, and it was the Civil Rights Act of 1861. Okay, excuse me, 1871. Excuse me. All right. Okay, so the next thing act we have is the Equal Pay Act of 1963, right? And basically, the Equal Pay Act says, you know, pay has to be um, paid out or given, based on the level of work, equal skill, effort, and responsibility, and that gender should not play a role in, how much someone get paid. Right? People should get paid equally regardless of gender. And so, the Equal Pay Act of 1963 is what kicked in order to try to alleviate the gap between men and women's pay who are doing the same job. Okay, and even till this day, women make, I think, 75 cents as compared to the every dollar a man makes, and it's actually grown. Right, it used to be 50 cents to a dollar, and so we've gotten better, but it's going to take some time to get to where it definitely is equal pay on every level, right? And so if you look at how long this act has been around, and you think about, what year we're in, and we still having this problem, right? Um, it just goes to show you that yes, you can put an act in, and you could put, certain things in, but doesn't necessarily mean it's going to be changed, right? Doesn't necessarily mean that things are going to, get better necessarily, right? So they gotten a lot better, but they're necessarily not where they need to be, right? Exceptions to equal pay, right? A bona fide seniority system, right? Where, of course, that's based on, hey, the longer you've been there, the more pay you're equal to. So, regardless of if someone comes in at the same position as you are, they haven't been there as long, you've been there, longer than them, boom, you get more pay than them just because it's based on seniority, and seniority normally equates to experience a lot of times, right? Quality of job performance, right? So we have merit-based pay. Okay, so sometimes, one person to do a job better than another, or the outcome of one person's work is better than the other. So depending on how that particular project is set up, or whatever thing they're working on, however it's set up, there may be some merit pay there based on how well we do, right? Next one is quantity of output, right? Maybe it'd be compensated based on how many particular widgets you produced, right? So if the base is hey, 100 widgets, right? Anything over 100 widgets, you get an extra 10 cents, right? And so you'll see the difference in pay because of that. Some people will do 110, other people will do 120, someone may do 150. So you have to kind of keep that in mind when you're looking at how that works, right? And that's what they mean by piece rate pay systems, right? Um, Factors, contingency other than sex, right? There's other things in the workplace, that may equate to more money, more maybe a certification, maybe a higher level of degree or something to that effect, right? And so you have to account for those things, right? But gender should not be a factor in whether or not someone gets paid more than you, right? If we're coming in the same level of education, same level of experience, we bring the same things to the table for the most part, and we're on equal footing, then I should get paid the same as you, regardless of whether I'm a woman or not. Okay. All right. The next thing is Civil Rights Act 1964, and so now, come 1964, this is a more comprehensive, a bit more meat to it, and it really outlines, the protections and the recourses for minorities in the workplace. All right. So you have Title VII, right, which is really the most important one that applies to the workplace. All right. And it prohibits discrimination based on the classes of race, color. The protected classes is really the right term, on race, color, religion, sex, and national origin. That means that I cannot discriminate in hiring, firing, promoting, right, evaluating by using any one of those criteria. Okay, it should be based strictly on the person's skill set. Okay, Title VII applies to all private employers with 15 or more employees. Okay, state and local governments, any institution really. Okay, you have 15 or more employees, you are subject to Title VII of CRA 64. Okay. Within that, also the EOC, all right, um, was established to make sure and enforce the rules of Title VII, right, and to make sure that hey, people had somewhere to go if they felt like something was amiss. Okay, now the next thing we have is the ADA, Age Discrimination Act of 1967, and basically prohibits discrimination against employees age 40 or older. Now, this may seem like a stupid, oh, no, let me say stupid, a kind of a not a unnecessary act, right? But the thing is that before, anybody that was over 40 had a hard time in many instances getting a job because at that point you were considered old. And a lot of companies, they want to take a chance on you because they felt that because you were old, they really couldn't change. get you to change up, how you did things, right? You can't teach your old dog new tricks, right? That's first thing. Secondly, the older you were, the more likely, that equated to experience, which equated to higher pay, all right, to more money, all right. And so a lot of employers, they want to really deal with that. Why would I pay you more money when I can get somebody out of college and kind of mold them and teach them what I need to teach them and pay them less, all right? And they're the company, and they'll be with the company longer, right? Which is the other thing that you have to think about, okay? Um, in addition, which is a bigger one, all right, bigger issue for most companies is that as you get older, right, you have to start thinking about more about medical expenses and insurance and the coverage that people require as they get older. And so companies did not want to necessarily deal with that, right? Hiring someone who's over 40 more likely will have, comes with it issues of, the things that you have when you get older. And it's not the same thing hiring a 25-year-old and hiring a 45 or 55-year-old. They more likely are going to have some medical issues that will require insurance that the company is going to have to, uh, contribute to in paying the bills. And so companies didn't want to do that. Okay, so you look at the ADA and how it's kind of affected the workplace. Now, 40 is no longer considered old, right? 40 for the most part nowadays is just okay. You're 40, great. Even 50 nowadays is not considered old. So when we start talking about old now, I think because a lot of people in the workplace are a lot older, right? We have young folks, but we definitely have older demographic in the workplace. People are working longer, and so this act sometimes comes into play now, but a lot of times it doesn't. But there have been two recent cases where people have filed for age discrimination. Okay, but they've been a little older, so you kind of have to look at it, in the context of nowadays. They may need to kind of amend this one and change the age to make it a little older because people are hiring people over 40. It's just the whole point of okay, is this person bringing the skill sets that I need? Can I negotiate a pay that seems fair to them and to us, and those kind of things? Okay. All right. The Rehab Act of 1973. All right. So this particular act was really um, put together, right? And it doesn't necessarily explicitly say so, right? But this is where discrimination was prohibited by the federal contractors, right, against handicapped employees or applicants. All right, and so um, if the handicapped individual is otherwise qualified aside from their disability, all right, then you should not discriminate against them. Okay, um, of course, um, if they can't do certain things, then that should be evaluated against the job to make sure that okay, a person's blind, so apparently they cannot drive a bus, right? They can't, right? That makes sense, right? But this act, if you look at the time frame, was really a way in which the government was trying to make sure, or at least help, Vietnam vets, okay, folks coming back from the war who had suffered, major injuries and who were handicapped in some shape, form, or fashion. Because you got to remember, those guys that came back from Vietnam, a lot of them, were missing limbs, were relegated to wheelchairs, were blind in one eye or two eyes, or Agent Orange. There were a number of things that um, those particular veterans went through that a lot of times caused employers to discriminate against them, right? Because they didn't want to deal with those things, right? And so the government stepped in and said, "Hey, you know what? You want to deal with us? You want to work with us? You have to have a percentage of your workforce be, handicapped folks or folks that necessarily aren't fully capable physically of doing something, right? But if they're technically sound, they could do the job aside from their, being in a wheelchair or maybe, being blind in one eye, then you should definitely consider for harm, or at least they can't be disqualified or discriminated against, right? But the thing is that you have to think about reasonable accommodation, all right? And so with reasonable accommodation, that particular concept says if I can do something as an employer that is not going to be a financial burden to the company in order to hire someone or to, promote someone or to keep someone on, then I should do those things. Then I'm required to do those things. Okay. And so when you think about reasonable accommodation, let's think about someone in a wheelchair and there's no elevator in the building. Okay. And so if there's no elevator in the building, it's not reasonable for the most part to ask the employer to build an elevator or put in an elevator because that's an exorbitant expense. Now, depending on the size of the company and that kind of thing, and what building it is, because most buildings, 9 times out of 10, have an elevator, right? There are some other ways in which we can hire someone who is in need of an elevator or in need of a way to move from one level to the next, and still, have them hired and fill the position, right? But again, reasonable accommodation only goes so far. So employees have to be willing to also compromise, right? Or potential applicants, right? They have to be able to compromise. And so if they come in and you know their office or the office is going to be on the second floor, it's okay for the employer to say, you know what, we'll put you down on the first floor, right? And then that way you don't have to, you don't need to come upstairs for any reason, right? And you do need to come upstairs for some reason, there's a meeting or something upstairs, we'll have to figure that out, right? Or maybe you can do it via a Zoom or some kind of VTC or something to that effect, right? But they figure it out. Okay. All right, Pregnancy Discrimination Act of 1978. This one is extremely interesting and still, still, still goes on. Pregnancy Discrimination Act still goes on, right? And so this prohibits employers from discriminating against pregnant employees, right? And they should be treated as any other medical issue, right? When you talk about discriminate against someone because they're pregnant, right, it doesn't require them to return to the same job. Okay. It just means that, look, I'm not going to you know I'm not gonna get rid of you, I'm not gonna not hire you, I'm not gonna not promote you because you're pregnant. Okay? That's pretty much what it boils down to, right? um, you cannot, at the same time provide health plans that don't offer pregnancy, that don't cover pregnancy, right? That's one of the things. You cannot, determine, when a person can, take leave or maternal leave, right? Because everybody's pregnancy is different. Some people from the onset have a hard pregnancy. Others, they're fine the whole time and they just need a couple weeks, to recover from when they have the baby, come back 2, 3 weeks later and they're fine. Others, they may need 6 months, right? It all depends. So employers are not allowed to dictate when the dates of leave are, and they have to leave a position open or the ability for the employee to come back to the company in the same position at the same pay or higher. Okay, the pay cannot be degraded, the position can. Right, they don't necessarily have to come back to the same level of position, but their pay cannot decrease. Okay. All right. ADA of 1990, American with Disabilities Act 1990s, right? Again, kind of goes along the same line of the Rehab Act, the Vocational Rehab Act 1973. Just a little different, all right? Because now this one deals with private companies. The Voc Rehab Act is more or less with government contracts and that kind of thing. Okay. So ADA deals with more or less with, private companies that have 15 or more employees, right? And so with that, you again, same type thing. You have to, be able to apply reasonable accommodation, okay? And if otherwise, if not for that disability, could the person do the job? Yes. Then you need to not, you can't, disqualify or you can't discriminate against them because of their particular medical condition, okay? And so when you talk about disability, one of the things that you have to really take into considerations is, what impact does it have on major life activities? Okay, and so if it doesn't have a major impact on major life activities, is it considered a disability? Okay, which is the other thing. Some people get headaches, and that constitutes a disability if it's been diagnosed by a doctor. There's documentation showing like this person is definitely suffering from headaches and is in treatment and that kind of thing. But as long as it's recognized by a accredited or licensed physician, and the company knows about it, right? The company, you need to be very open and transparent about your disability, because not all disabilities are necessarily disqualifiers, but some can be, depending on what it is, because the company may not be able to reasonably accommodate that person's need. Right? If someone has an issue with their vision, right, and it just requires me to get them a bigger screen as an employer, right? Maybe I get them a bigger monitor. Maybe I get them a 50-inch monitor because they have trouble seeing. Right? That's fine. Okay, because I can afford that. It's not gonna cause any undue financial burden, right? But then again, if we go back to the elevator situation, trying to put an elevator in, that might cause me some undue financial burden, because putting an elevator in is not cheap. We're talking about $150,000 at minimum, right, to put an elevator into a building, right? And again, depending how tall and high the building is and that kind of thing, right? It may cost more, it may cost a little less, right? And so you have to look at that also. Okay. Um, California's AB 2222, right? And just a little bit less restrictive for employees to show disability, right? Again, no limit to damages. Okay. The burden of proof is shifted from employee to employer, which is um, you know, different than federal law, right? The burden of proof is typically on the employer, right? If the employee puts in a files a grievance, um, and it goes to the EEOC and it goes to the company and that kind of thing, for the most part, it's on the employer to disprove the claims, right? Disprove the accusation. Where the California AB 222, it's up to the employee to prove their claim. Okay, it's to prove their claim. All right. So a lot of times, California HR laws are basically laws that are used as templates by other states. Right. For whatever reason, California a lot of time is a little more ahead of certain things, a little more progressive in how they think about things, and so some of the laws that they have will be kind of emulated by the states, because other states like them. It seems that because these things are protecting corporations and helping them save money, right, and not unduly unjustly or unfairly have to spend money that they really don't want to, or they shouldn't have to, right? And so again, if you look at California's AB 2222, you'll see that it's a little different from the federal anti-discrimination laws, but at the same time, it's just a few changes. But depending on the setting, right, the um, the federal statute will definitely take precedence over the state statute, depending again on the situation. All right. All right. Some amendments that have been made to the ADA. Okay. So it requires that impairments be evaluated out considered mitigating measures. Right. Disabilities which are episodic or in remission are protected. Okay. So basically, if you have something that's not necessarily constant, it kind of comes and goes at episode, like say seizures, or someone who has epilepsy, right? Kind of comes and goes, right? So you may, cancer remission or something to that effect, right? Um, that's covered also, right? Specific major life activities, right? That's covered, right? Eating, sleeping, walking, standing. Those are life activity that those are things that we need to do, to live, right? And so they're required, of course, by companies, to be able to do. But at the same time, if you can't do them, how are those things happening, and how can I accommodate as an employer, right? So I can bring this person on who has this disability that affects one of the major life activities. Okay. Lowers the standard on determining whether individuals regarded as having a disability, right? And so it makes it a lot easier to qualify as having a disability. Okay, if we lower the standard, right? And then directs EOC to reinterpret sustainability limits to significantly restricts. Okay, so substantially limits to significantly restricts. So we have a change in wording here that will again um, uh, help to kind of decide what's a disability, what's not a disability. Okay, so you kind of have to look at it and say, okay, how's that wording change from substantially limits to significantly restricts, right? Again, makes it a little bit harder to maybe qualify for being a disability per se. So if it's not qualified as a disability, then the company has a little more leeway to bring the employee on, but also they may not have to accommodate certain things. Okay. All right. So we have CRA 1991. All right. So we went from 1866 to 1871 to 1964, which is probably the biggest, most revamped version of the act, right? And then you have the, Civil Rights Act 1991, and this one shifts, right, burden of proof, right, on part of the employers, as I was saying before, right. So now the employers have to disprove any claims that is made, right. It also allows litigants to sue for compensatory and punitive damage. Basically, I can sue the organization, the company, right, for compensation and other damages based on if they did something wrong to me. Okay, if they did something illegal, if they treated or discriminated against me, I can sue for compensation and punitive damages based on what they did. All right. Family Medical Leave Act of 1992. Now you have 12 weeks of unpaid leave for birth, right? The act only covers organizations with 50 or more employees, okay? The employee must have been working for a minimum of 24 hours per week or 1,250 hours yearly. All right, employees in top 10 employees' salary range is not covered. Okay, so this is an important fact. Employees in top 10% of employers' salary range is not covered. That's because they figured those people can cover their own medical and family emergencies. Okay, so they need to take time off. More than likely, those folks are capable of taking time off without it being a huge burden on their finances. Okay. Employers should be required to continue employers' group health coverage during leave, right? So I mean they can't stop the insurance, all right? And the employer must be allowed to return the same equivalent job, right? So if I leave for a number of weeks, I should be able to come right back to the same old job that, basically I did the same thing at the same pay, all right? If not higher, okay? It can't be lower, all right? Another thing that Family Medical Leave Act, covers is, military deployment. So if a family member is deployed, immediate family member is deployed, and they're coming back, you can use the Family Medical Leave Act in order to take time off to be with them, right? Because they're coming back from, a hazardous, arduous situation, and so you can use the FMLA in order to take time off to spend time with your family. Okay. All right. Uh, Genetic Information Non-Discrimination Act, basically GINA, okay? And GINA really comes from the fact of that um, whenever people want to get a job, a lot of jobs used to require physicals, which I'm sure they still do. Some jobs still require physicals, right? And the organization would set up the appointment with their doctor, and you would get physically checked out, and then the doctor would write a report stating, what how you how what your level of fitness was, or what your physical condition was, basically. right? What was happening is that because the organizations were paying for the doctors, the they felt that the doctors were obligated to provide them with information about whether or not a person was genetically predisposed for a certain condition, right? The person is, may have the gene for, diabetes or cancer or breast cancer or some other disease, right? And so companies were using that information in order to disqualify potential candidates or potential employees, right? And so they put the GINA, the Genetic Information Non-Discrimination Act, in play in order to protect people's information, right? And then employees can no longer reach out to the doctors and ask them for information related to the particular candidate, right? And so, if it wasn't anything that was detrimental, was going to cause um, some um, or have an impact on the company, then they couldn't say that. Even if they did have something, they'd have to get permission from the particular candidate or from the person, and then they could kind of go from there. Okay, and so you have to be careful about how you collect information about employees, right? Because the GINA Act will kick in, or GINA will kick in, and you really, can get a lot of trouble for that. Okay. So let's talk about the EEOC, right? Equal Employment Opportunity Commission. And this commission, again, was formed in 1964, right? And basically, it's the governing body that, you know, resolves um, grievances and issues that an employee has with an employer. Okay. And so here the process is outlined. Okay. When you look at it here, okay, look at the process. All right. It's a pretty lengthy process. It takes some time, right? It's never real easy. Okay. But, kind of starts here with the actual discriminatory act. The employee files a claim, right? And then the state local folks, they will go ahead and take a look at it and that kind of thing, and do the investigation at the state and local level. Okay. And then the complainant is not happy. All right. Doesn't really work out for them as far as like what they were looking for. Okay. No problem. Now they will go to the actual EEOC, the federal uh, level, okay, and then that gets sent to the employer, right, and then an investigation will start from the federal standpoint, right, from a federal level, okay. EDC ruling, right, reasonable cause found, conciliation efforts initiated. So basically, EOC will get with the employer, and the employer, hey, what can you offer this person as a remedy or recourse for what was done wrong, because we established that there's reasonable cause, and so you need to fix this, right? And so if if the conciliation efforts are, once they're initiated, if something is agreed upon, right, then everybody says good to go, and then they sign the agreement, and then that's done, right? And then boom, EOC decide not to file suit, right? Issues a complaint against a right to sue letter, right? So that kind of closes out, and the EOC does nothing after that. They just kind of, they're done, right? Um, Once that is, that's good to go, right? Now, what if there's no agreement that's reached, right? Then the EOC issues a right to sue letter for the complainant or the person filing the claim, and then that person can then uh, file a suit in federal court. Okay, um, so let's go back up here. Now, the EOC ruling, there's no reasonable cause, right? So that means the employee who filed a claim, there's nothing to substantiate their claim. The EOC dismisses the charge. The individual can sue using their own lawyer. Okay, if then an agreement is reached, great. Okay, if not, again, EOC does not decide not to file suit, issues a complaint, a right to sue letter, so they can go ahead and sue. Okay, and break and sue. All right, and so it's a pretty lengthy process. You can see there are time hacks here. in order to keep the process moving along, because these things can take time, and the employer who has a lot of resources can actually stall, um, to where the employee or the litigant runs out of money. Okay, and so we don't want that, right? So that's why there's a timeline, as to how quickly these things are resolved. Okay. All right. Now let's talk about disparate treatment and disparate impact. Okay. So when we talk about disparate treatment, we're talking about discriminatory practice against an individual. Okay. Basically, where whatever's happening is just happening to a person, or maybe two people, whatever the case may be. Disparate impact is different. Disparate impact is that whatever discriminatory practice is going on is having an adverse impact on a larger group of folks, right? Um, so we're talking about, hiring practice that may affect, all, women, or all African Americans, or all Caucasians, whatever the case may be, right? That's disparate impact. It's having an impact on a large group of folks, right? The thing about disparate impact is that, you know, as compared to disparate treatment usually is intentional in nature, right? Disparate impact sometimes can be unintentional. Companies can take action and do something which they don't necessarily view as discriminatory, but results in, discriminatory outcomes, right? And so, let's say, for example, um, a situation where they're trying to save money, and they decide, you know what, we're going to take out all the um, toilets in the bathroom, and we're just going to have urinals. Okay, urinals are great, but at the same time, um, they don't accommodate women, right? And they don't accommodate also other bodily functions aside from just urinating. Okay, and so although the company meant well because they wanted to save money, the actions that they did discriminated against a certain amount of folks, right? So that's disparate impact. That's unintentional disparate impact. Unintentional, intentional, it doesn't matter. You're still liable for that action, and it's the same consequence if you don't remedy it as quickly as possible. Okay. So the four-fifths rule states that if selection rate for protected class is not 80% of selection rate for majority class, then a prima facie case of adverse impact is established. So basically, all it's saying is, look, if you select, 80% of the majority class for a particular job, right, and that's the average rate of selection, but you don't select at least 80% of the minority groups, right, or a protected class, then you have an issue, right? Then we have a prima facie case, which basically on the surface, right, as we look at it, it meets the requirements for a discrimination case, right? Because the four-fifths rule is saying that you haven't selected enough people from the minority group in order to make it match up with the majority group, right? Or you've selected too much out of the majority group, right? And really discriminate against the minority group based on, one of the protected classes. All right. So when you look at employers rebutting discrimination cases, excuse me. All right, they have to show that the discrimination or the reason that they disqualify the person has to do with the job, right? They don't have a particular skill set. They don't have something, that needs to be, part of their job duties. Okay, they can also claim BFOQ, which is the bona fide occupational qualification, that says the person has to possess a personal characteristics or be a member of a particular group, right? So this is interesting because um, you know it, it's situational. Okay, you have to look at the particular situation and figure out, okay, is there BFOQ that applies here that we can use in order to discriminate against this person and not hire them? Okay, and so there was a case in California here a while back where a particular person went to work at a adult uh, um, men's club. Okay, and so the person put the application in, and the application specifically asked If the person was pregnant, the person's put down yes, and they were disqualified for the job. Now, the issue that the person had was that they were not yet showing, right? They weren't as far as they weren't demonstrating that they were pregnant because you couldn't see it. They were at that point yet where they were presenting as pregnant, right? And so they felt that because of that, they should have got hired. But the employer used the BFOQ and said, well, we're not going to hire you because you're pregnant, right? And being pregnant, right? One of the things that was required for this particular job was sex appeal, right? And from a from their standpoint, organizational standpoint, no one's going to think that being pregnant is sexy, and working in an adult entertainment environment, being pregnant is not necessarily something that is considered uh, sexy. I mean, you need sex appeal for this particular job, and so they use that as a disqualifier. Okay, and the person took the organization to court over this, and the person lost. All right, the litigant lost. All right, because the company had a valid, point in that being pregnant does not equate to being appearing sexy, right? And a lot of folks don't find that sexually appealing, and so that is one case, right? A bona fide, a BFOQ in its use. Okay. Also, business necessity is another defense that companies use in order to, um, discriminate against employees or potential employees. Okay. Um, they can't lift. One that's pretty common is that we this job requires you to lift 60 pounds. Okay. Where there are other ways in which people can lift 60 pounds, not aside from being physically, able to do it. I could use a machine, I could use a lift, I can use, I can get someone else to do it. There's another number of ways to get around that. So that business necessity doesn't necessarily, work anymore. But there are still some cases where business necessity and BFOQs most certainly apply. Okay. Voluntary mediation program. All right. Uh, uh, Designed to be fair, impartial, and unbiased. And basically, um, it's just a program set up so that um, there's a way for us to come to the table and resolve your issue without going to court, without it being drawn out and expensive. All right. And so that is really what the companies are leaning towards. Okay. Looking for the least expensive way in which to take care of things. Okay. But sometimes employers may decide to take employees to court because they know employees don't have the resources per se to really go long term, as far as a dispute in the courts. And so a lot of times it's a long game, and it normally plays out to the benefit of the employer because they have more resources. So most, employees kind of want to get in and get out, unless the legal team that they have is working on contingency. And so they're working on contingency. They basically say, look, we don't get anything unless you win. Okay, unless you win, we'll get something. But aside from that, we will cover all the costs. Um, and so usually, if a lawyer takes a case and she is working on contingency, they probably have a really strong case, or at least feel that way, right? And so they go and take the case on contingency. All right. The next thing we're talking about, executive orders, and executive orders are something that issued by the president. Right. If the president, decides he or she wants to pass a certain, you know, um, law, or wants something to happen, there's certain, things that they can make happen via executive orders. Okay. And so based on that, they apply to everyone, and so it depends on what it is, right? So for example, we have a student loan issue that we're trying to resolve now, right? Student loan forgiveness or debt forgiveness. And the president, based on what I've read and what's out there in the research, can eliminate or forgive some school debt, off of, from an executive order, and doesn't have to necessarily go to Congress or, um, any governmental agency to um, ask for that, right? And so, um, an executive order is a pretty powerful thing. Okay. All right. So let's talk about some affirmative action. All right. So affirmative action basically is a program, right? And listen to what I'm telling you. Affirmative action is a program that's voluntary in nature. Okay. That was put in place to help organizations become more diverse. Okay. That's the whole point. Right? We're looking for diversity. We're looking for fairness. Looking for opportunity across the board in a fair and measured and balanced way. Okay. Affirmative action is not mandatory unless and until you violate some kind of discrimination law, and then the government will come in and mandate you to implement affirmative action plan. Okay. So it's not necessarily, something that you have to do, right? So the second bullet says required for organizations with 100 or more employees or 100 employees, uh, and with 50,000 or more in federal contracts, okay? So you have to have both, all right? Both with 100 or employees with 50,000 or employees with 50,000 or more in federal courts and federal contracts, all right? So a lot of times companies don't have $50,000 worth of dealings with the government. They may have no federal contracts. Okay, again, as I said, this is just a plan. It's a guideline. It's a suggestion per se, right? Where you see this really in play is in the school system, university system, where they apply affirmative action to admissions, right, and try to give opportunities to folks that didn't have opportunity before because based on their race, their gender, they were disqualified immediately and didn't have a fair shot at really getting into a particular university. And so the university is obligated to some standpoint, to some degree, to bring in a certain amount of students that are, female, that are African American, that are Asian, that are Caucasian, depending on, the school, right? Everybody has to, should strive for diversity within the institution, right? But affirmative action plans, were put in place to level the playing field, right? Didn't provide any, special or um, special, circumstances for the minorities. What it did do though was say if the person, as long as the person is qualified, right, then they should be considered for the particular position or spot or admission. Okay, qualified. Okay, and so if it takes a B average to get into Harvard, right, a 3.0 is the minimum qualification of Harvard, and you have people that meet that requirement, right, and they're going against people that have 4.0s or something like that, doesn't mean they're not qualified. It just may mean that the folks that they're going against may have a higher qualification than them. Okay. But at the same time, they're still qualified, right? Because that doesn't isn't really indicative of their performance. It's not indicative of how they will perform. Okay. So you have to, pay attention to that. Okay. So four separate sections about affirmative action, all right? Utilization, all right, and analysis, availability analysis, identification of problem areas, and narrative statement of corrective action. Okay. When you talk about utility, right, the employee identifies the employees by one of the protected classes, okay, be it gender, race, ethnicity, religion, whatever the case may be, okay. Availability, right, talks about looking at, employment of all, availability of employment, all the protected classes, right? Is the person, really able to secure a job, right? What's the opportunity available to them, right? um, Identification of problem areas, right? Looks at, if the person of the companies, has too little or too much of a certain group, right? Isn't utilizing those particular groups in a way that makes sense. Okay, if you have an organization and it's 99% male, you probably have a problem. Okay, you probably have a problem with you need to resolve in getting more females, more women into the organization, right? Creating more diversity, right? And then you have to have detailed plans with timetables, right? So you have to kind of look at all that. All right, sexual harassment is another big one, okay, which is makes up a majority of the cases that you'll see in the EOC and in the courts, right? It just um, sexual harassment is it's just uh, rejection or offensive and inappropriate advances, right, and unwelcome, okay, advances towards a person. That can include touching somebody's shoulder or saying things that makes people uncomfortable, behaving in a way that makes people uncomfortable, right? Or you can also have quid pro quo, which is this for that. So if you want to get promoted, if you want this job, you have to sleep with me, or you have to perform some sexual a favorite or something like that to that effect, right? So that's definitely a big deal when you come to sexual harassment. As I said, quid pro quo, right? A hostile working environment is the next thing, right? Again, where you create an environment to where the person who's you're bothering you, it just has anxiety coming to work. It's just not a friendly environment, and they feel that you know uh, it's just threatening, right? Um, Harassment standards used by the court, right? You reasonable woman, it's same thing as the reasonable man test, right? Would a reasonable person think this is harassment, right? No legal jargon, no fancy stuff, just like a common sense approach to it. If I was just a regular guy on the street, would this be considered harassment, right? And that's the test. You also look at pattern behavior, right? And see, okay, does this person habitually, create a harassing situation and that kind of thing, right? And so you have to, look at the basis of that, or is it an isolated incident, right? And then you also have to look at how did the organization respond to the allegations or to the situation in trying to rectify or come to some resolution for the parties. All right. So when it comes to sexual harassment, you want to make sure you investigate all allegations. Okay, not knowing or I didn't realize it was happening is not going to help you. Okay, thorough and prompt investigation. Right, the person doing the investigation should be unbiased and objective. All right, no retaliation takes place. So basically, you can't get back at the person who's filing the harassment claim. Right, you still have to treat the person that uh, treat the accused, right, the person that was accused of doing the harassment fairly. Okay. Once everything is done, you have both parties sign written statements to prevent facts from changing, right? Once I do my investigation and we've looked at, what we think happened or what occurred, and both sides concur, come to a consensus, then everybody will sign the paperwork saying, yes, these are the conditions that existed, and this is the story, this is the narrative that we're going with. Okay, and this will be used in order to figure out, okay, what do we do now? Okay, what action do we take? What punishment or remedies are we going to provide? Okay. Um, Take prompt action, okay, and equate consequences with behavior. All right, so let's, if the person, it just was rubbing the person on the shoulder, we're not going to necessarily fire them. Okay, we're going to probably provide some training, like as far as personal space. Ask the person, hey, don't do that anymore, or we may very well just move the person to a different department, in addition to having them, you know, adhere to some of these particular rules. Other times, a person may have sexually assaulted the person, and so that may require firing and also some criminal charges and that kind of thing. Okay. The thing is, when you're dealing with in an international settings, um, a lot of companies culturally, well, some cultures don't necessarily acknowledge sexual harassment in the workplace, right? Because they just see it as just the way things are. It's okay. I'm not, doing anything. I'm just really trying to take her out, um, or take him out, or whatever the case may be. And they don't see it as something that is necessarily an issue. Okay. Um, you should definitely, when it comes down to it, from a legal standpoint, um, the person being harassed should definitely tell the harasser that, hey, I don't like this behavior, right? And to let them know, like, okay, back up. I don't we need to establish some rules in our relationship, okay? And I don't want to be touched by you. I don't, I don't want any sexually, laced conversations with you, okay? Um, but of course, the burden rests on the employer of establishing, communicating, implementing clear policy. So it's really up to the employer to make sure they have some kind of policy, some kind of, some set of rules that are out there that are accessible, so people can blatantly see, okay, these are the rules, and these you should not break these rules. Okay. All right, some trends in employment litigation, blatant to subtle discrimination. Okay, we're definitely seeing an increase in that, but we're also seeing an increase in diversity in the workplace. Okay, um, use of electronically produced and stored evidence. Now, instead of paper work, a lot of things are being transposed and put into digital documents, and so it makes it easier to, one, search for things, two, easier to maintain, and you can keep records of things for ever, really, now that things are being digital. All right. There is increasing complaints of employee retaliation. Again, employers feel like that the employee is levying a claim or a grievance against them, and so they may come back to them by cutting hours or demoting them on that kind of thing, right? There's also an increase in ADR, right? Alternative dispute resolution, which is mediation, arbitration, or something that effect, where we're not going to court. We're just kind of saying, based on the paperwork you signed when you took this job, you um, you signed away your rights to go sue first, right? You have to come and do some kind of alternate dispute resolution. And if we don't have anything from that, then at that point you are allowed to go get a lawyer and that kind of thing, and go to EEOC and those things. Okay. Um, we're also seeing, more expeditious employee settlements. So basically, employers are not wanting to waste time or money in trying to, deal with things in court. They will more likely settle with the employee, whether that be a monetary compensation or whatever remedy, whatever issues they had. Okay. Um, language rules in the workplace. So basically, hey, if we're supposed to be speaking English in the workplace, then more than likely we would try to stick with that. Speaking another language or different language in the workplace, usually frowned upon, just because now we really don't know what you're saying. You could be talking about us or saying something derogatory that may not be true, and so really, advocating for the use of, whatever the language of the land is, and that's what we use. Okay. All right. So with that said, that concludes this presentation. Okay. If you have any questions, again, feel free to reach out to me, and I will see you next class.